I'm going to be looking at some of the challenges. I've just sort of boxed them down to 4 main challenges because obviously we've got a limited amount of time. And those challenges are, as you can see here, we're going to be looking at those in some detail as I go along. The first one is the evidence. So here it comes. The first thing, surprising though it may seem, is it the right evidence? You'd be surprised how many times it isn't the right evidence. I can give an example from quite some time ago of in a criminal case where lawyers came to me and they sent me a DVD of some video of a contested incident. Well, it was a DVD of the video. It wasn't the actual video. It wasn't the real original video. And because it had been put on a DVD, of course, all the dates and time stamps were simply the date and time stamps that the video had been put on the DVD. So that could not be correlated with the incident itself. So I had to ask for access to the laptop, the original laptop upon which the video was made. I was given access to that. And ultimately, having had a really good look around the hard drive, there were indications that it was very probable the video had been tampered with. So it is important to make sure that you've got the right evidence. Another common example of not the right evidence, particularly in corporate cases, will be copies of digital documents. Now, usually they ask you, can you verify the dates and times on this digital document? Can you say if it's been tampered with, blah, blah, blah? And they'll send you a digital document that's been sent to about 14 million people as well. It's gone all around the houses, and finally it's come to you. And the clients are constantly surprised to find that the expert cannot actually wave a magic wand over these and uncover verifiable dates and times or text modifications, or even any other type of suspected shenanigans. And again, you have to advise them that you need to go back to the source. You need to get as close to the original as you can. Oh, by the way, the same is true with email trails. Excuse me, I've got a frog in my throat. Email trails is another popular one. They'll send you a whole trail of emails. Well, of course, you're only going to get the email header out of one of those. You're not going to get the email headers out of all the rest. And again, you know, they're quite often amazed at the point at which they decide to bring an expert in. That you can't just click your fingers and get them exactly what they want. Here are some of the other challenges that you find when you're out in the field. Where is the evidence? Who's got it? In criminal cases, that usually means tracking down the officer in charge of the case, otherwise known as the OIC. And the officer may be on leave, maybe on a difficult shift. It may be quite hard to track him or her down. They may even have moved force since the charges were presented against the defendant, because cases take a terribly long time to get into court. It can be 18 months before a case comes to court, and often the officer might have moved on by then, so some other officer has to pick it up. They don't know half of where the evidence is or what it should be, and you know, and how they can even get it to you, or how you can get to it. So who's got it? That's a primary concern. And where is it is even more fun. In corporate cases, that's often extremely unclear. The evidence that you might need for the case could be on one or more devices, internally, externally. These devices might be office owned, or they might be owned by an employee, which potentially presents more difficulties. It could be on an owned server, it could be on a leased server, or it could be in some cloud repository, such as Google Drive. It may or may not still exist, of course, by the time they get round to asking you to come and look at it. And if it does exist, let's say it's somewhere like Google Drive, and people are accessing it all the time in real time, then the dates and times associated with the artifacts that they want you to look at will be very difficult to verify and could change on the fly. There are some other additional problems that can arise. One common problem, especially in corporate cases, is that you may be only allowed to look at a subset of data. So not the entire, all the all the digital data off the device or devices that are part of the inquiry. I had a case some years ago where a barrister's laptop had been stolen by somebody. Actually, it was from a robing room in a court. Now, the defendant had actually been doing other things as well, but and that they caught the defendant, and they wanted to find out what, amongst other things, what the defendant had been doing whilst he was in possession of the laptop. But unfortunately, because it was a barrister's laptop, it had client details on there and letters and emails and heaven knows what. So, of course, that was protected information. So what they did was, although the prosecution in that case did have access to the entire laptop or the hard drives thereof, what they gave to us, or me rather, in the defence, was 1 gigabyte of data. 1 gigabyte of data from a 250 gigabyte hard drive. 1 gig. However, there was a very handy little artifact in that 1 gigabyte of data, and that was a log record. It was a nice little log record that had been made by an onboard modem, which detailed the make, model, and serial number of the laptop. Now, because I was reviewing the details, as I always do, I always look at all the bits of paper that come with it. I was reviewing the details of the chain of custody document produced by the prosecution and the supporting photographs. And I noticed that the prosecutor's operative had noted the correct make of a laptop, but the wrong model. And of course, that didn't accord with the photograph. They also hadn't noted down the serial number of the laptop. Well, that was major. So now, as a result, the hard drive that was in the laptop could not be conclusively tied to that computer. And as a result, the defence made an application to exclude the computer evidence. And the judge agreed. So the computer evidence got thrown out on that basis. I should perhaps point out that the defendant was convicted on other issues, but this example serves to show how important it is to pay attention to detail, especially when recording device details and when you're putting down things in the chain of custody documents. Absolutely vital if you want your evidence to stick.